Chapter 20, Transfer of Title. In this chapter, we're going to be able to describe the four methods of title transfer, and we're going to explain the process of the transfer of title of a deceased person's property. So title to real estate means ownership of the land. It's just a word that means ownership. There's no document in real estate called title. It's just a word that means ownership. Alienation is the transfer of title to a parcel of real estate. When you alienate yourself from something, you're separating yourself from it, right? So alienation of real estate means that you're separating yourself from the real estate. You're selling it, you're giving it away, you're leaving it to somebody after you die. So there could be voluntary alienation, which you get to dictate who gets it, or involuntary, where you don't, right? So voluntary alienation alienation can occur during your lifetime or after you die. And it can be voluntary or involuntary. Voluntary is something you want, involuntary is something you didn't have a say in. At death, voluntary alienation is through a will, or involuntary alienation would be if no will is left, because the state will get the property by the process of escheat if no heirs can be located and you died without a will.
During a lifetime or death, voluntary.
So at death, voluntary through a will, or involuntary if no will is left, because the state will get it by the process of escheat if no heirs can be located and you died without a will. I know I could add some commas there. It's like one big run-on sentence. I know. My grammar's horrible. But now we're going to highlight title to real estate, because this is on, what page is that on? The first page of chapter 20?
373.
Is this on the same page?
Yes, 373.
The 373. So let me put a page number in here on this slide while you guys do your highlighting there. Mm-hmm. Okay. So you're just highlighting title to real estate means the right to or ownership of the land. And then you're writing above that second paragraph there, alienation, the transfer of title to a parcel of real estate. So this chapter is going to discuss how title can be transferred during your lifetime, voluntary or involuntary, and at death, either voluntary through a will or involuntary if no will is left.
The transfer of a title.
Give me a second, okay? Alienation. The transfer to okay. Thank you. Alienation.
So voluntary alienation of title can be by gift, sale, or exchange. The owners use some form of deed to convey their ownership during their lifetime. Or you use a will to transfer voluntarily upon your death. Right? You don't use a deed to transfer ownership after you die. Okay, the seller needs to sign the deed. Can't sign it when you're dead. How do you transfer ownership after you die? By your will. That's why you make a will. A will only takes effect after you're dead. A deed, you need to be alive. Deeds, the transfer of ownership takes place upon delivery and acceptance of the document called the deed. Has to be delivered by the seller to the buyer accepts it. That's when the transfer of ownership takes place. So
deliver to ownership, right? Mhm.
if you filled out a deed to sell your property to me and you die before you get to deliver it to me,
Okay.
the transfer of ownership never took place
Okay.
because there has to be a delivery and acceptance of the deed itself.
Yeah, because it got to be signed, right?
Yeah, this actually became a big deal. I forget who it was, but it was in New Jersey. There was one of the old Motown divas. Uh, she was selling her estate. She was selling her property, and she signed the deed, and she had named who the buyer is in the deed because the lawyers prepared it all. They FedExed it to her. She signed the paperwork. Now she just needed to bring back the deed and deliver the deed. And then the seller, I'm sorry, the buyer was going to be wiring the funds into her bank account. Okay, they
Mhm.
were just
Mhm.
doing it this way. So they were doing it by phone. They had four-way phone conversations with the attorneys. The attorneys prepared paperwork, FedExed it to them. They went over, where they needed to sign and date and all that stuff. She just never had an opportunity to deliver it because on her way to deliver it, she dropped dead.
Mm.
She had a stroke, heart attack, whatever it was. She dropped dead in her house when she was on her way to deliver the deed. So the ownership never took place. The transfer of ownership never took place.
Right. So that's what is considered voluntary.
Well, hold on a second. So when you die, how do you transfer ownership?
Mm.
Upon your will,
Transfer on.
with a
Wait,
will.
say that again. With the will.
When you die, how do you transfer ownership? You can't use the deed. The deed's no longer valid. You're dead. If you never delivered it, you're dead.
So you say a will.
A transfer of ownership has to take place through a will where you can leave it to somebody. But in this
But if
case,
she didn't have a will.
she was actually going through a sale process. She had attorneys. The seller, the buyer, and each one of their attorneys were all on the phone together. They were FedExing documents. They went over with each other to sign the documents. Now she just needed to put it back in the FedEx to deliver it. But she dropped dead. It was in the envelope, even the FedEx envelope to send it back. She just needed to drop it off at one of the FedEx drop boxes, right?
Mhm.
So her kids, they said, nope, she never sold the house. We got the deed here. She never actually delivered it, so we get to keep the house. That's what
Was
her
that
kids
in her
said
will?
because her kids were living in the house still. Yeah, in her will, she left everything to her kids. However, remember, she signed this deed. She was on the phone with everybody's attorneys. They were doing this conversation that she was going to sign the deed and she was going to return it, which she signed the deed and she had it in the FedEx and she was headed for the door and just dropped dead.
Mhm.
And the seller already wired her the funds. So the kids were like, we get to keep all the money in the bank. That's her assets. And we get to keep the house. No, you don't.
No, no,
Because
No,
the
you
deed.
don't.
because she signed those paperwork.
That money was wired to her bank accounts by the buyer. And she said, well, I'm running out the door right now to put it in the FedEx drop box. I signed it already. And so everybody was a witness to this on the phone. Both sides, both
Right.
parties, her own attorney and the other side's attorney and the buyer and her. And she even signed it. And she had it back in the FedEx envelope. That's irrefutable. But she
Right.
didn't, the delivery and acceptance didn't actually take place because she dropped dead just before. So now we're
Right.
getting into a technical area. But
Mhm.
the judge in this, because the kids were greedy, they wanted to keep it all. They wanted the money in the bank and they wanted the house, but you don't get both. You know,
Right.
so because you could prove that the seller wired the funds there, and both attorneys agreed that it was for the purchase of the of the house. You know, so uh, the judge said, well, because of the evidence of all the attorneys and everybody on the phone there, and because of the evidence that she actually signed the deed and she actually put it in the FedEx envelope, she just didn't get to deliver it. There was an implied delivery. Okay. Implied is a contract that is made by one's actions. And her actions of signing the deed and putting it in the FedEx envelope and being on the way out the door and saying it, and everybody witnessed that verbally, the judge said the sale took place. So the kids don't get to keep the house. They could keep the money that's in the bank account because she left it to her assets to her children, but they don't get to keep the house, even though she left the house to the kids in the will. That's why we need to update wills when we make changes. You know, if you leave something to someone in a will, a car, you leave a car to your kids or somebody in a will, can you still sell that car while you're still alive?
Yeah.
Sure you can. It's yours to do
Yes.
it. Now
Yeah. Yeah.
you just
You
should
can always
update
change
your
your
will.
will.
Yeah, you should just update your will because you no longer have that
Right.
car, you know. So that's the thing that happened here because she was in the process of selling the house there. So I guess she didn't update her will yet. So it still said that, the kids get the house, the kids get her bank accounts and all of her assets and all that. So the kids they were kind of greedy for all that, They seen all that money in there for that mansion, they wanted to keep that too. But they didn't. You either get the money or you get the house, not both.
So how long do they get to get out the house?
ASAP. Listen, they knew their mother was selling the house when she was alive. It wasn't a shock. She wasn't hiding it from them.
Mm-hmm. They just was being greedy, like you
Just
said.
that they got greedy. They wanted it both. They're like, we got the money. You wired it to us. We got the house. She never delivered the deed. We get to keep
They
it.
thought they was coming up.
Yeah, no, it don't work like that. No. And so judge made the decision on that one for them. Okay, so that's an interesting, unique version of it. But usually, when the transfer of ownership, there has to be a physical delivery of the deed and a physical acceptance of it, because that's when the transfer of ownership takes place. But this was a unique situation because everybody was on, the conference calls. She signed it. She even signed it when she was on the phone with them. She put it in the self-stamped, addressed, paid for envelope for FedEx that they included when the attorney sent the documents to her. It just didn't occur. So that's a little bit unique there. Okay, so transfer of ownership to or from the government. We give property to the government through dedication. Dedication is giving land to the government for a public use such as streets, schools, and parks. Giving land to the government for a public use like streets, schools, and parks. So that's dedication. Here, let me give you an example of where dedication would take place as an example. Say I own a big property. I own a big lot. It's so big I could probably put 6 houses on it. I subdivide it. I put a street down the center of the lot that's basically a cul-de-sac, which is like a dead-end street, right? With that circle at the end. And I subdivide the lot and I build 6 houses on it. I sell all 6 houses. That street was built on my private property. I get to name the road in my plans for getting the subdivisions approved. But in there, I have to write, am I going to keep that street private that then I need to maintain? I need to make sure that when it snows, the snow is removed and all that. Why would I want to do that after I sell all the houses? I wouldn't. So I'm going to dedicate the street to the city. So now it's a city street, which I named. by the way, because I named it because it was built on my property, so I get to name it. Okay, that's how it works. I did the subdivision, I named the street, and then I dedicated it to the city, so now it's a city street. So that's what dedication is. When you give land to the government for public use, like streets, schools, and parks, and that's one example where you would give some land to the government, usually in a subdivision like that. You may even build a park or have a grassy area that's not part of any of the individual lots for the individual houses. So you would dedicate that land to the municipality for use
As
as
a vol as a volunteer, like you get money or no? You ask for the money?
You're giving it.
You're
giving
giving it. Okay. Okay.
Like I built that. I subdivided my lot and I built 6 houses on it and I put a cul-de-sac street on there. I don't want to keep ownership, maintaining of that street.
I see.
City's
Okay.
not going to buy it from me. I'm just going to give it to them. So
Okay.
now it'll be a city-owned street, and now they're responsible for maintaining it.
Okay.
Okay. When the government gives, anybody gives property, you're granting the ownership from one party to another. So when the city gives property to a private individual, it's called public grant, granting the ownership to you. So when the government gives public land to an individual for private use, they do so by public grant. Okay. So let's highlight voluntary alienation, about dedication and what public grant is, involuntary alienation, and then escheat down here, which is when a person dies intestate and leaves no heirs, the title to their real estate passes to the state by escheat. So if you die and no heirs can be located and none step forward, the city or state, the government will sell that property at public auction, and the proceeds will be held in a fund for 1 year, in which time your heirs can step forward and claim ownership. But if they don't, the state gets it.
1 minute. Give me a second.
Yep.
Ownership.
Can you say that last word? Escheat?
SG. Mm-hmm.
Escheat. Okay.
Let me put it another way. When you die intestate, that means without a will, and no heirs can be located, the state will sell your property at public auction and put that money in a fund for a year. And if you don't claim it, they keep your money. They escheated you out of your property.
Oh.
Now, they're not,
Basically, cheated you out of your property. That's the way to look at it. Cheated.
they're not cheating you out of the property, but that's the way I remember. You got escheated out of your property. I got the rubber neck and everything going on. they escheated you out of your property. All right, so everybody got that?
Yeah. Yeah.
All right. So involuntary alienation, once again, is a transfer without the owner's consent. And this could be done by escheat. Because if you died without a will, you didn't get to say who gets your property, right?
Mm-hmm.
So it's without your consent. So therefore, escheat is involuntary alienation. Or eminent domain, that's when the government takes the property for a greater public good, but with just compensation. So the owner needs to be compensated for the property. But they took your property away. You didn't have a choice. That's a form of involuntary alienation, because that's what involuntary means. You didn't have a choice. They took it from you. Or when your property gets foreclosed upon because you didn't pay your debts, you didn't pay your taxes or your mortgage loan, you could get foreclosed on.
I did not know if you don't pay your water tax bill, they can foreclose on your place.
Water tax, it depends. Water and sewer, if they're billed by the city.
Mm-hmm.
So if it's municipal water bill or if it's a municipal sewer bill, then that could be sold at auction just as it'll be sold at the tax auction. Okay.
I got a letter. I said, wait a minute, hold up, what's going on?
You can lose your property
Yeah.
tax auction if you don't pay your water bill or your sewer bill. Okay. But only if it's municipal.
Only
Okay.
municipal.
Yeah, like if you get your water bill from American Water, no, they can't foreclose on you. Okay. They can just
Oh,
in collections to get the
City
bill
could do-
paid, right? But if it's municipal, because on it has the name of your town water, like I know Rahway is municipal water, so you get your water bill and your sewer bill from the Rahway Water and Sewage Authority. Roselle is the same thing. Roselle Water and Sewage Authority. Linden, it's American Water. You know, it's not municipal, so you can't be foreclosed on for not paying your water bill. You could just, you know, they could turn off your water and put you in collection.
right.
You know, but anytime you get a municipal bill, it's just like the taxes. You know, they'll put it to auction, and if you don't pay it, somebody can actually foreclose on you for non-payment of your water bill or your sewer bill. It's the craziest thing. Can you imagine?
And they
For like $300 bill or even sometimes. I seen one lady in Rahway. She actually had her house up for sale, and she had and then I noticed that her property was on the tax auction block too, and it was because of the municipal water and sewer bill, and it was over like a ridiculous amount. It was like $150 or something like that, and she didn't pay it, and so it went to the auction. Now the person pays the bill at the auction. They don't get your property right away. There's a 2-year right of redemption. So she had 2 years to pay that person back that paid her water bill. She did not pay it in 2 years. They foreclosed and got the house for $150.
$50. That just happened to my girlfriend. Her father was like going through Alzheimer's and he forgot to pay his bills.
Yeah.
And they sent I forgot how she found out, but somebody went and started purchasing on the house. And he had to pay the bill and then pay her back her money for him to get the full rights to his house again.
Yeah, the municipality will be sending you bills. You know, hey, you know, you're late on your water bill. It's a municipal bill. You need to pay it, or you could face foreclosure. You know, so they'll have the tax foreclosure auction, but tax foreclosure auction is different than the lender's foreclosure auctions. At the lender's foreclosure auctions, when you buy a property at auction, you get the property and you get the ownership at that point. When it comes to taxes, at least in New Jersey, when it comes to taxes in New Jersey, if your water bill's municipal and it goes on your tax bill, if you don't pay it, the person at the auction has to pay your taxes. And so what they're bidding on at the auction is not how much they're going to pay. They have to pay the full amount. What they're bidding on is the interest rate they're going to charge the homeowner to pay them back. And the homeowner will have 2 years to pay that bill, pay them back plus interest. And if they don't pay it back within that 2 years, then they could lose it because the winner of that auction now that holds that tax certificate can take you to court to do the official foreclosure, which is a lot swifter because they've already been waiting 2 years, right? So they could get that done a lot swifter to get the ownership of the property. But the homeowner, they'll get a notification by mail that, hey, there's going to be a tax auction on your property. You got to pay the bill. They send you a million notices, so it's not a surprise. But even if they don't send you that notice, you've still been getting the bills the whole time along. You're late, you're late, you're late. You're going to get late fees and penalties, possible legal action, you know. So the sale will still be valid. But they'll inform you at some point there, hey, your tax bill was paid at auction. You have to pay back now that money plus interest. And you got 2 years to do it. Okay, so court action, through court action, partition proceeding, or suit to quiet title. So partition is when you own a property with someone else. They don't want to sell, you do. you're not stuck owning the property. You could try to sell your partial ownership interest on your own, but that may be difficult to do without somebody buying the entire property. They're only buying your partial ownership interest. That could be hard to sell. So you could go to the other co-owner and say, "Can you buy me out?" And they could say, "I wish I could, but I don't have the money." Or maybe they have the money and they don't want to. Are you stuck owning the property with them? No. You could take them to court, what's known as a partition proceeding, where a judge will see if this property can physically be partitioned. And if that's not possible, they'll order the sale of the property, and the owners will get their shares of interest from the proceeds of the sale. But that other owner didn't have a choice. The judge ordered them to sell it, so therefore it's involuntary. Adverse possession. That's like when a squatter is squatting on your property without your permission. They're occupying your property. If they're there for a long enough period of time as defined by law or as prescribed by law, they could take you to court and then claim ownership of the property.
Where did that squatters come from?
Anywhere.
No, I mean, like, where did this law come up to? Like, where is their rights and stuff came from? They always had this?
Yes, it's always been in place to make sure that all land that's publicly available is being fully utilized. Its main purpose was meant or geared towards farmland, because everybody was farming, in the origination of this country. You grew your own crops and stuff like that. Everybody was involved in doing a little farming and gardening, right?
Mm-hmm.
So they wanted to make sure that all land that was available for public use was being fully utilized.
Oh.
And so as long as it's being used and the taxes are being paid on it, it's the government don't care. But if it's somebody's using your property without your permission and you don't take action to get them removed from that property, and they're there for a long enough period of time as defined by law or prescribed by law, then they could claim ownership of the property. They could take you to court, sue you to gain ownership. Okay. Now, in New Jersey, we're going to go over what that period of time is. We're going to go over it right now in this chapter, briefly. I don't want to spend a whole lot of time on it in this chapter, because chapter 7, we dive into it a little deeper. And then erosion. Erosion is done by Mother Nature. It's an involuntary form of alienation to Mother Nature, because Mother Nature wears away your land by wind or water, right? But that was involuntary. You didn't give up that land. Mother Nature took it from you. Yeah, she had a sinkhole, right?
Yeah.
You had an earthquake, or you had a landslide, a mudslide, a sinkhole, or whatever other way that Mother Nature involuntarily took your property away by erosion.
Oh, that's a good example.
Yeah. So partition proceeding, let's highlight that. This is on page 375 on the second paragraph. Partition proceeding, one co-owner seeks to force another to divide or sell property. Okay. So here's some forms of involuntary alienation. The escheat. Person dies, intestate, no heirs can be located. The process is escheat, and the property is taken by the state. If the land is needed for a public use, using the powers of eminent domain, the public or governmental agency takes the property. If you don't pay your bills, non-payment of a debt secured by real property, the process is foreclosure in New Jersey, and the sheriff sells the property to the highest bidder. And through open, notorious, continuous, hostile, and adverse use of another person's property for a prescriptive period, through the process of adverse possession, a suit for adverse possession has to take place in order to perfect an easement by prescription, where the adverse possessor will then gain the ownership.
Wow.
Okay, so we already highlighted this now on page 375, second paragraph, right? Partition proceeding, one co-owner seeks to force another to divide or sell the property.
Correct.
All right. I'm going to have a couple slides here about adverse possession, even though we mainly focus on this in chapter 7. But here's the basic rundown. So I'm not going to waste a lot of time on it. I'm just going to go the basic rundown right now really quick. And chapter 7, if you got any more questions when we get to it, we'll go over it there in any more depth. So an easement by prescription. Well, first of all, what is an easement? An easement is a right of somebody to enter the land of someone else for a particular purpose. And once it's been established that somebody has an easement right to be on your property, you can't take it from them. You can't take someone's rights from them. They can give them up, but you can't take them from them. However, an easement by prescription is a little bit unique because you never gave somebody permission to be on your property. They're squatters. They're using your property without your permission. So that's why they also refer to it as adverse possession. It's adverse towards your ownership. They're adversely possessing the property without your permission. So when you use someone else's property for a period of time as defined or prescribed by state law, you can claim ownership of that property that's being used. To perfect this easement by prescription, it requires a court action called a suit for adverse possession, or sometimes it's referred to as a suit to quiet title, to claim ownership of the land. Now, the use must be continuous, hostile, adverse to the owner's title, exclusively used, and without the owner's approval. Additionally, the use must be visible, open, and notorious. It can't be like, yeah, during the night, I dug a ditch around their house and buried an underground doggy fence. So I've been using it in secret and nobody's been really knowing. It has to be obvious that you're using the property. You're using it out in the open, against the owner's permission. They're not taking any action against you to remove you from the property. So it's visible, open, and notorious that you've been using that property. Now, the prescriptive period in New Jersey is 30 years if it's improved land. So what is an improvement?
30 years?
What is an improvement? It's anything that's man-made, a man-made addition to the property. It could be a paved road. Doesn't necessarily have to be a structure that's on the property. It could be a paved road, or it could be a sewer pipe. Any kind of manufactured addition to the property is an improvement. So if you have a property that's improved, the prescriptive period is 30 years. That squatter has to have been using your property for 30 years before they can claim ownership. If you don't take action to get somebody to remove from your property that's using your property and you don't want them on your property and they've been using it for 30 years, you probably deserve to lose your property.
Right, because how you let somebody live there for 30 years?
You know? If it's unimproved lands, it's just raw woodlands, the prescriptive period is 60 years that they had to use your property before you could file a claim of adverse possession.
That's like me owning acres and then some people decide to live in my acres and I never knew about it.
Yep, somebody puts up a tent in there. Well, the thing is, it has to be out in the open and obvious that they're using it. Now, if you don't know about it, what, in 60 years, you didn't walk across that area of your property to notice it?
No, it's full of weeds. I mean, full of trees and stuff.
The owner should then, if it's raw land, you should at least once every 60 years then walk the boundaries or take an ATV out there and drive it if you got that much land on your land to make sure there are no adverse possessors of your property. And if there are, you better take some legal action to get them to removed from that property. Otherwise, you risk losing it.
Mm-hmm.
Now, this law is going to change sometime in the future. I have no idea when. But I do know that the law is going to be changed to the common law period of 20 years. So it doesn't matter if it's improved or woodlands, it's going to be 20 years. Now, when is that change going to occur? I have no idea. I've been following this for 17 years.
Wow.
The politicians in New Jersey, there was a court case 17 years ago that somebody wanted to take away a property by adverse possession. It was two commercial property owners, right? And one said that they were using the other's property. They put a fence around it even. They were using the property for 17 years. I'm sorry, they've been using it for at least 60 years. And they put a fence around it and everything. And they took them to court to try to claim ownership. And the actual owners of the property brought up a good point. Our New Jersey politicians created several laws that cover the same topic that conflicted with each other. There's one that's a 30-year period for improved lands. There's a 60-year period for unimproved woodlands. And there's a 20-year common law period that says that, well, after somebody's been using your property for 20 years, they have to file the suit. So these additional laws that New Jersey politicians created, the 30-year improvement or 60 years for unimproved woodlands, didn't say anything about doing away with that 20-year common law period and overriding it. So therefore, they had to work in conjunction with it. So if unimproved use of a land, unimproved land use is a 60-year period, prescriptive period, and you have to file the lawsuit after 20 years, well, after 20 years, you don't meet the requirement to successfully claim the ownership, which was the argument in court. But it doesn't matter because the common law, because the way the politicians in New Jersey wrote the law, they didn't put an exception to the common law period that requires you to actually file the suit after 20 years. So there's a conflict in the law there. And because of that conflict, that person did not win the lawsuit to claim adverse possession and gain ownership of that land that they've been using for more than 60 years. And the judge made the right decision in this case by kicking it out of court. He kicked it out of court and said, I cannot rule on this one way or the other. Reason being is the politicians in New Jersey, they're the ones that make the laws. As a judge, I don't make law. I simply interpret the law and I render a decision based on the law. But there's several laws that cover the same topic that are conflicting with each other. So I'm going to kick this back out to the politicians to fix the problem. There's a conflict in the law. I can't rule in one favor or the other. So you're not going to successfully win this adverse possession suit right now. So he kicked it back out to the politicians to fix. So it went to the politicians, and the politicians said, okay, we're going to do away with the 30-year period and the 60-year period, and we're going to go with the common law 20-year period. And they agreed on this, and now it has to go up for a final vote. It's been sitting there waiting for the final vote for 17 years now that I've been tracking it. Me, Victor Kaminsky. Okay. Even the book manufacturers don't know how this works, because if you actually read on how it says in the book, it says, well, the law seems to side with this or that. You know, they don't know what's going on. The politicians know they're changing the law. However, they just haven't did a final vote on it, which is amazing because this is their job, right? To vote on these things. They're already in agreement. They know what they want to do. They just need to vote on it. It's actually still sitting there on the legislative thing waiting to be voted on. 17 years. Somebody needs to bring it up for a vote. Now, if they want to create a new gas tax, what does it take, 30 days? Booyah! But to cure up conflicts in the law because the politicians made up more laws covering the same topic that then conflicted with each other to clean up their own messes. 17 years so far, I've been counting. It's amazing. So for exams right now, I'm telling you what it's going to be. It's going to be 20 years. But as for right now, on your exams, When they ask you, what is the prescriptive period for adverse possession? And if they tell you there's any improvements on that property, what is the prescriptive period?
30 years.
30 years. But if it's unimproved or vacant woodland,
60.
60 years. That's what you need to know for exam. You need to know those time frames. 30 for improved lands, 60 years for unimproved. Okay? Now, how could somebody, wait. Before I get into that question, I should read the last bullet point. Through the process of tacking, what is tacking? Well, tacking is when successors in interest, like a landlord or a tenant, an ancestor, an heir, a seller, and a buyer, they could add one person's time of possession to that of another, combining them to reach the prescriptive period. So let's just say my dad was squatting on this property for the last 40 years. And it's got an improvement on it. I'm his successor in interest, and I take it over. I could tack on, I got to be there for 10 more years and squatting on that property. So I could combine his time onto mine to reach the prescriptive period because we're successors in interest, ancestor and an heir, right? So we're successors in interest. I could take on his time, tack it onto mine to reach the prescriptive period. So even though I've only been there for 10 years, well, my dad was there for 20. So we add them together, that's 30 years. So we could do that legally. Now, how can a homeowner, a property owner, prevent somebody from gaining an easement by prescription? Well, they can take legal action against any adverse possessor and get them removed. Right? Call the cops, file a complaint, get a court date, get them off the property. They could cut off their access. They could put up a fence around the property to cut off their access of stopping the continuous use, and that resets the time clock, in which then they have to start all over again that prescriptive period, and that should give you plenty of time to take them to court and get them removed from the property. Or you could give them permission to use your property. Remember, one of the ways to get adverse possession is the use must be continuous, hostile, adverse to the owner's title, exclusive, and without the owner's approval. So if you give them permission to be there, they can't claim adverse possession. So send them a certified letter saying, you've been squatting on my property and using it for X amount of years without my permission. However, I'm going to give you my permission now to be on it until the end of the month. And then you got to get off. So what did I do by giving you permission? I reset the time clock. So if they were there for over 30 years, but they haven't yet claimed adverse possession, well, I could step in there, give them permission. I reset the time clock. It has to be 30 years of use before you filed that claim for adverse possession. So I just reset the time clock before you ever filed that claim. Even though you met the time period requirement, you never filed the complaint. So you have to file it in court in order to gain the ownership. And you didn't do it. I found out about it. I gave you permission to get to use the property till the end of the month, but then you got to go. So I just reset the time clock. So you'd have to be there for another 30 years before you could claim that. And I ain't going to let that happen. I'm going to take legal action to get you removed now. Okay? Mm-hmm. So that's how that works. Now, some states have different prescriptive periods. You take a look at Florida, for example. I'm going to show you a couple examples in Chapter 7 where people try this, using adverse possession to gain ownership of somebody's property. In Florida, it's only 7 years. Okay, now, you cannot claim an easement by prescription against government-owned property, but against publicly owned lands. Okay, only against privately owned properties. All right, so let's do these highlights. I'm going to put these up on screen for you guys to highlight. All right, so we just went over the unclaimed property and unclaimedproperty.nj.us website. I didn't have the recording on since I took the break after that
Uh-oh.
previous one. That's all right. I just didn't go over the slide here, which I went over this one, and you did the highlights. Yeah, because I think it was just this. We already went over this, and then we went over this with the highlights. And then we went over this with all the different terminology. And if you're watching this video now and I did not go over this, well, you could just pause it and read through these things right now, get the explanations. I'm not going to go over them again. And then here, let's highlight this. And write this note on the side of the page here. Remembering legal terminology, OR versus EE, page 120. Okay. There's actually a chart in chapter 7 that goes over the fact about, remember I told you about words that end in EE versus words that end in OR. Words that end in OR is the person giving whatever the root word is talking about. Words that end in EE is the one that's receiving it.
Mm-hmm.
So you have devise is when you leave property by somebody in a will. Devisor is the one that left you the property in a will, and the devisee is the one that's receiving that property in a will.
Wait a minute. What did I just do?
So on the side, you're just writing see page 120, remembering legal terms. OR, and you put that in quotes, in capital letters and in quotes, verse EE. So there's a chart there for all kinds of terms that begin with that have R or EE in them, and then you can see who the players are. They talk about devise, devisor, devisee, lease, lessor, lessee, mortgage, mortgagor, mortgagee, all kinds of things like that.
What is this? Give me a second. Honest devices.
In our book, they got the ORs. Give to the EEs always.
That OR is giving, the one who's giving, EE is the one that's receiving. So the words that end in OR is the one, this is a good way to remember the legal terminology. They're the one that's giving something, words in EE is the one that's receiving, whatever the root word's talking about. Okay, so as you guys continue to do these highlights, I'm not changing the slide. I'm just going to start reading something here on this slide, okay? So continue doing your highlights if you're still highlighting and taking the notes. In New Jersey, children can be disinherited. So your parents can write you out of a will. They don't have to leave you anything. So be good to your parents. Not just because you want them to leave you something, but because they're your parents, for crying out loud, So in New Jersey, children can be disinherited, but a surviving spouse is entitled to at least 1/3 of the estate. You can't write your wife or husband out of your will. Well, you could, but it doesn't mean anything because by law, they're entitled to at least 1/3 of your assets. And the determination of the augmented estate is a complex calculation. In a case where a will does not provide the minimum statutory inheritance, the surviving spouse has the option of informing the court that they're going to take the statutory share rather than any lesser share or amount that was provided for in the will, left to you in a will. So can your spouse leave you less than 1/3 of the estate in the will? Could they totally write you out of the will? Yes. But it doesn't mean anything if you know the law. You could say, no. Instead, I'm going to exercise my right of election. That's what they call it, where you're entitled to a minimum statutory share of 1/3 of the estate. And that's only reserved for a surviving spouse. Children can be written out of the will. A will differs from a deed, though, because a deed conveys your present interest in the real estate during your lifetime of the grantor, while a will conveys no interest in the property until after the death of the testator. To be valid, a deed must be delivered during the lifetime of the grantor, which we already spoke about this a little bit.
Mhm.
The parties named in a will have no rights or interest as long as the party who made the will is still alive. They acquire interest or title only after the owner's death. And anything that they may have left to you in the will, they could still sell it when they're still alive. So if they left you a house, but they sold that house while they're still alive, and now they don't own the house, even though it says that they were leaving you the house in the will, you get nothing now because they didn't own it anymore.
Right.
So here's that chart from chapter 7, OR versus EE. Don't worry about it. We're going to have this. You don't got to go switching back to page 120 in chapter 7. Well, when we get to chapter 7, I'll have this slide up again where you guys can write this in there and highlight it, okay? A person must be of legal age. So I told you guys all, you need a will. Everybody needs a will, okay? So who can make a will? And what are the requirements for making a will? Well, a person, you got to be of legal age and sound mind to sign a will. That's what they mean when they say execute a will. They're talking about signing a will. You have to be of legal age and sound mind. What is legal age? 18. You got to be 18. You got to be of sound mind and at least 18 years of age.
What does sound mind mean?
And the making of a will has to be a voluntary act free of any undue influence by other people. Yes, if you have Alzheimer's or dementia, you're not of sound mind.
Okay.
So any will that you may have made could be detested by, detested? That's not the right word. Contested. It could be contested by others. Okay, so any person of sound mind who's 18 years of age or older can make a will devising of their real property. All wills must be in writing to be valid. Yes, video wills are not legal in New Jersey. You could make them for dramatic purposes if you like. You could sit there and record yourself so they could see you talking to them. And this I'm leaving to you, and you could explain to them why and everything like that. You could give a little story to people and record a video of yourself for your will. But you need to have the will in writing too. Okay? The will must be in writing. Video wills are not legal. They have no legal force whatsoever. Okay? You could create one just so that you could talk to people face to face, through the video, but that's only for dramatic purposes. In reality, it needs to be in writing. Now, the general rule is that a will must be witnessed by two persons. Someone who's a beneficiary in the will can also serve as a witness. Now, if the signatures of the witnesses are notarized within 2 days, the probate proceedings can be simplified and go through a lot quicker. A holographic will is a completely handwritten will. You didn't type it up. You didn't print it out. It is completely handwritten. And this does not require any signatures. It does not require the signatures of any witnesses anyway. So the person who made the will, if they completely wrote that will in their own handwriting, that's known as a holographic will because it's hard to forge an entire document. Okay. So under New Jersey estate planning law, holographic wills can be probated and will serve to ensure the testator's assets are bequeathed according to the testator's wishes. And for real property acquired by married deceased persons before May 28, 1980, they have that dower and courtesy rights. Okay. So the surviving spouse is still entitled to a life estate of 1/2 the interest in all real estate owned by the deceased, no matter what other provisions are made in the will. That's after May 28, 1980. Before May 28, 1980, your spouse is entitled to 1/3 of the entire estate for all the property you own.
Mhm.
After May 28, 1980, the spouse is entitled to a life estate of 1/2 interest in all the real estate owned, no matter what the other provisions are made in the will. So title to real estate and personal property of a person who dies intestate passes to their heirs under the descent statutes. And the primary heirs of the deceased person is their spouse, civil partner or domestic partner, and close blood relatives. Now, when children have been legally adopted, most states consider them to be heirs of the adopting parents, so they can still inherit from their adopted parents. But they do not become heirs of the ancestors of the adopting parents because they're not blood relatives. In most states, illegitimate children inherit from the mother, but they do not inherit from the father. So what is an illegitimate child? Now, some of these rules, some of these laws start to sound like they come from medieval times, and they do. They're old. What is an illegitimate child? Your
Like a
parents
child
were not,
outside of.
yeah, you were born out of wedlock. Your parents were not married when you were born.
Mhm.
Okay, so illegitimate children inherit from the mother, but they do not inherit from the father. Wait, what? Yeah, yeah, you're a real relative. But because your parents were not married when you were born, you don't inherit from the father automatically, not unless he admitted parentage in writing or parentage has been established legally in some other way, like a blood test or something. Now, if he legally adopts his own child that was born out of wedlock, that child inherits as an adopted child would from the father, but not his brothers and sisters and aunts and uncles, his side of the family, which is pretty messed up because that child is truly a blood relative. You know,
That's they got me kind of confused. 'Cause I'm like, I understand what the illegitimate child is,
yeah.
but when you say that he goes adopt his child, why did he have to adopt his child? That's still his child, even though they weren't married. He's on the birth certificate.
Maybe, maybe not. If he's on a birth certificate, well, then parentage has been established that way.
Oh, okay.
But once again, if he legally adopts his own child, even though you're the parent,
Mm-hmm.
that child would inherit like an adopted child would from the father, but not from his side of the family. I know it's messed up. It's messed up. But these are old laws, and that's the way the old laws were made, and they never changed them here in New Jersey. That's how they still stand.
Got it.
Okay, so here I like to liken this to we all like shows like Game of Thrones. Anybody ever see Game of Thrones? You know that was a very popular program on HBO. Game of Thrones. It
I
was all
heard about it, just never
medieval
watched.
things and such. You got the kings and queens, and who has the right to take the throne? Well, you have no right to the title of the throne because you're the bastard child. You were never married to your mother was never married to the father, right?
Mm-hmm.
It's the same kind of wording here, because back then in medieval times, the king would have a wife, but he could also have his woman on the side he has children with too, but that's the bastard child born out of wedlock. It's the same. It doesn't matter if, he was married or not to anybody. When you're not, when your parents are not married together and you're born, it's considered under the eyes of the law. You're an illegitimate child and you inherit from the mother, not from the father, unless he admitted parentage. And then if he admitted parentage, you could legally inherit from your father, but not his side of the family. Which, yes, I know it's messed up. So let's continue reading. So what happens when you die without a will? Well, the law states that the first thing is your estate needs to be probated. So all debtors need to be paid first. So if they didn't pay their taxes, taxes need to be paid first. along with any other people who lay claim that he owed money to. Now, the law of descent comes into effect only when the descendant leaves no will. A surviving spouse or partner become the sole heir if the descendant leaves no parents or children. If there is a child or children who are also the children of the surviving spouse, the spouse or partner receives the first $50,000 plus 1/2 of the remaining estate. The rest goes to the child or children. If the descendant leaves parents and a spouse, but no children, the spouse or partner receives the first $50,000 plus 1/2 of the remaining estate. The rest goes to the parent or parents. If there are children who are not children of the surviving spouse, you had a child with someone else, the spouse or partner receives half of the estate, the child or children the other half. Where no spouse or partner survive, children become sole natural heirs. Where there's neither a surviving spouse nor children or children's own heirs, the estate first goes to parents, and failing that, goes to your brothers and sisters or their heirs. In default of any other natural heir, grandparents, aunts, uncles, and first cousins only may be considered heirs. Beyond that point, the entire estate goes to the state of New Jersey by escheat. So how does escheat work? The state treasurer sells the property at a public sale, public auction, giving notice by publicizing it in the newspaper in Trenton and in the county where the property is located. The proceeds of the sale are held in a fund for 1 year, and if no claims are made within the year, the funds belong to the
Belongs
state.
to the state.
They escheat you out of your property. So you can go to unclaimed.property.nj.gov to see if there are any claims there or any property that you may lay claim to, or missingmoney.com if it's which New Jersey used to participate in. They pulled out, they made their own one, that unclaimed property page. Missingmoney.com for other states. And that concludes this chapter. So chapter 20, let's do the key terms to review in chapter 20 now. Get there. All right, there's one key terms on page 378. So before we get started, go down to letter L. And where it says one who can inherit, I want you to write blood relative or blood relatives after that.
Heir.
Where it says one can inherit, write blood relatives.
That's the heir.
Mhm. Actually, you could write blood relatives or adopted children. Adopted children, they could inherit from their adopted parents only. They cannot claim to be heirs, though, of
the deceased.
of the father's side of the family, or the mother's. Actually, they can't. If you're adopted, you can't claim. You can't claim to inherit. You can't make any claims of inheritance that you're due inheritance from your parents' parents or your parents' brothers and sisters, your uncles. You know, because you're not really a part of their family. You were adopted into the family. So your adopting parents, you could be inheriting directly from your adopting parents, but not from their bloodline, basically. Okay, so let's see. Let's do this. Person named by the state to administer descendants' will.
One, administrator.
An administrator, one is A, correct. Court proceeding to establish the validity of a will.
Validity. Court.
Court
Purpose.
proceeding-
Probate.
It's a probate court. 10 is B. Title acquired by usage. How do you, title means ownership, right? So ownership
Yeah.
acquired by usage. What kind of ownership do you get simply by using the land?
I got this one.
Adverse possession.
Yes, adverse possession. 2 is C.
Oh, I see.
The squatter's rights, right? Where they could claim
Mhm.
ownership because they've been using the land, they've been squatting on the land for long
Oh.
enough for the prescribed period of time.
Usage.
Yep.
Person name in a will.
A will to administer a descendant's estate. Who's a person that you name in your will to administer your estate, to make sure that all your final wishes are carried out as you wrote in your will?
That be your hair, your ear.
No.
No. The person, you have to specifically name somebody in your will to make sure
Executor.
wishes are carried out. That is your executor. You know, next to executor, put a slash and write executrix, because executor is only a man. Executrix is a woman. So write slash executrix. EXECUTRIX.
Where?
You're writing that next to 5 is D, executor. So right after the word executor, put a slash and write executrix. EXECUTRIX.
Correct. It's a D. Okay.
Yep.
Person name in a will to administer
Right
descendant.
next to number 5 there where it says executor.
Transfer of title.
Executor or executrix is correct. 5 is D. Transfer of title
Mhm.
without the grantor's consent.
Excuse me. Oh, transfer.
What do you call
That's a
ownership without your consent? Without your permission? Without your approval?
Oh, I can't think of this. My brain just went blank. A transfer title without the guarantee's consent.
testy? No. Transfer of title without a grantor's consent.
When you agree to do something, what do they call that?
Agree.
Voluntary.
That would be.
Invol-
So if you don't agree to do something, it is.
involuntary.
So a transfer of title without the grantor's consent is known as
Involuntary. It's involuntary.
alienation.
Oh,
Alienation is a transfer of property. Right? Involuntary alienation is without your consent.
Without the
invalid,
consent.
okay.
Yes. And without a will.
Yep. 8 is E as in Edward. What do we call it when you don't have a will? Without a will. You die without a will. What do we call that?
Intestate.
Intestate. 7 is. What do you call a person who makes a will?
The trustor.
No.
Testator. Testator.
Tested.
Testator, that's a,
Is G. 12 is G. Testator.
Because they're the one that's giving it.
that's a male, right?
But a testator is a man. Testatrix is a woman. So put a slash after testator and write testatrix. Test, T-E-S-T, the letter A, and trix, T-R-I-X.
That's the tricks.
Testatrix.
That's a G.
No, yeah, 12 is G. G as in
Okay.
correct.
So either one. Okay.
Gary, how about that? Because some people spell George with a J. so let me put there Gary, okay?
G
That
as
is
in-
disposing of property. after-
Gas. G for gas. There we go. All right. And then let's see. So 12 is G. Document disposing of property after one's death.
disposing property after the death.
What do we call the document disposing of property after one's death?
Last will and testament.
The last will and testament. Yes, 9 is H, as in Harry. Or Harry.
Where is that on?
9 is H.
We highlighted that in the book.
Yep. Yep.
Last will and testament. Why I don't have that? Oh, yes, I do.
Mhm.
Right in my face.
Documents disposing of property after one's death. Oh, we just did that. 9 is H. Having made will. What do we call it when you made a will?
Voluntary alienation.
What do we call it when you made a will? We're just talking about a will. You died with a will. What do we call it when you died with a will?
Oh, die with the will is a title? No,
Testate.
deed? No.
Testate. You died testate.
Testate.
Testate
Oh,
means
testate.
will.
Yeah.
11 is I. See, we got to study that. This is what I tell you, vocabulary is a big part of this exam. Now, they may not just give you a question like, what is testate or something like that, or what do we call one who died with a will? They could ask you a question like that, but the word testate could also be just a part of a question. That could be one of many terms that are used in a question. And if you don't know what testate is, or those other words that they probate or intestate or heirs or involuntary alienation, and they put all of those words or phrases in a question, you're not really going to understand what they're asking of you. This is why you need to really study the terms and definitions for exams. I know there's a lot of terms and definitions, but they could be. You may not get a question about one of those words. You could have many of those words in a question itself. And if you don't understand what they are, you ain't going to get it right. Okay, so it's important to understand the vocabulary and study the vocabulary. So testate 11 is I. Acquiring of property by natural heirs.
Acquiring a property. by
Yeah.
natural-
What do we call it? The acquiring of property by natural heirs.
Voluntary descent.
Can be voluntary alienation. No.
Acquire. Remember,
Descendant?
hold on a second.
Descendant?
Hold on a second. Remember, heirs are your natural blood relatives, right?
Right.
They're the only ones that can lay claim to your estate, or adopted children only for the immediate adopted parents. So every state has their own laws that dictate who can inherit, lay claim to your estate when you die without a will. We just read the whole process about it, right? About who can get your stuff when you die without a will. What did they
Yeah.
call that?
Descendant.
Descent. So descent and distribution. Every state has their own laws about descent and distribution of your assets. So yes, what was the definition here?
Acquiring property by natural.
Acquiring a property by natural heirs. That is
That's the
descent.
descent.
Yes.
Descent.
So 3 is J. One who receives real property through a will.
That's a voluntary alienation.
What do you call? Okay, here, let me put it another way. What do you call the person named in a will to receive your property?
Your
Heir.
heir.
Heir is somebody who's a natural blood relative who can lay.
Devisee. Devisee.
Devisee.
Devisee.
Devisee is somebody who's named in your will to receive.
Who's gonna receive?
Yes. So
Yep.
that's what the difference is. So 4 is K. Right? You have to be a family member to be an heir, right? You don't need to be a
That's
family
yes.
member to be a devisee. Devisee is just somebody, it could be your best friend. You left them something in your will. So they're one of your devisees. So
Right.
4 is K.
I see.
One who can inherit.
Heir.
That's the heir.
There you go. 6 is L, the heir. Transfer of title with the grantor's consent.
Finally, voluntary alienation.
alienation.
Voluntary.
Voluntary alienation with your consent. So 13 is M, and as in Michael, and then that concludes chapter 20.